Okay, welcome everybody to the Peaceful Presence Divorce Coaching Lunch and Learn series. My name is Kat Climaco. I am a nationally certified high conflict divorce, custody, and co-parenting coach and a domestic violence victim survivor myself. This community is near and dear to my heart, and I just want to let you know that navigating an abusive divorce takes a village, and I'm so glad that you're here. This Lunch and Learn series is all about rebuilding and healing and navigating the divorce. And this is a series where we have expert speakers come to share their wisdom with us. If you have any questions during the event, just go ahead and put them in the chat, and our wonderful moderator, Shruti, will pass them along to me for the Q&A at the end of the conversation. And just a quick reminder before we get started that today's session is being recorded for those who couldn't make it. So with that, let's go ahead and get started. I am thrilled to announce today's guest speaker, Dorothy Walsh Ripka. She is a seasoned family law attorney with over 2 decades of dedication to her craft, and she's licensed in 6 states. Although her expertise is sought after nationwide, her heart lies here in the Denver metropolitan area. Dorothy isn't just an attorney, she's a passionate advocate committed to crafting innovative legal strategies tailored to each client's unique situation. Today, Dorothy is going to fill us in on how recent family law changes affect your custody case. So welcome, Dorothy. I am so excited to dig into this topic with you. I'm going to let you go ahead and take it away.
Thank you very much for having me, and thank you everyone for joining us both now and later on as you watch this. I really think it's important to note that Colorado family law has undergone some major changes in the last 3 years, and those major changes point out to us and remind us how Colorado family law is not static. So information you received a couple of years ago, maybe even a couple months ago, might not be current. So it's really important to stay educated. And today my hope is to have a conversation. So if anyone has questions, you have the opportunity to put those questions in the chat. Happy to go off script, if you will, and make sure that this is as useful for you as possible. We're going to start a little bit just talking about the key takeaways of today. And the overhaul has happened completely of child support. There have been big changes in child support that just went into effect in March. There's also some new domestic violence considerations relating to spousal support and custody. There's a couple other little smaller things involving family procedure, involving some of the issues in DNN cases, which involve dependency and neglect. So we're going to spend most of our time today, hopefully, talking about the changes in support and then the changes that have evolved as it relates to domestic violence. And again, I want to point out that I think Colorado is making a statement here of saying that safety is important, and it should and can have financial impacts on a party that is a domestic violence abuser. And we're going to talk a lot today about what that really means and the nuances of what domestic violence, how it is now being defined and what that entails here in Colorado. And important to note as we get there, I'll remind you of this as well. This is new. It just went into effect last year. So this is a really evolving area because case law will definitely impact how we come to understand the impacts in the case. So I'm going to start real quickly with child support. There were kind of 2 pieces to that. There was a 2025 change that went into effect, which was via House bill. And there has always historically been a 92 overnight distinction between worksheet A and worksheet B. That distinction is gone. It's eliminated. There is no longer a threshold regarding the number of overnights to impact if you go to worksheet A versus worksheet B. That's really important because now every overnight counts, and it is now a sliding scale with gradual proportional credits being applied for overnights. That can and will mean people want to file modifications of child support. The same standard still applies, which requires a substantial and continuing change of circumstances, which is generally considered to be 10%. However, the new guidelines in sample cases tend to be having a 10% change if you apply prior information. They've done a lot of sample test cases. And so there can be a change of circumstances. So there's 2 pieces to that. Obviously, should you be evaluating for yourself, am I in a situation where I need to evaluate child support? But also, if you are the person who's receiving support or even paying support, you might wonder if there's going to be a support modification that you're going to be responding to. So now might be a good time to look over your calculations and have an idea if that's something that is affecting you. And the basic child support's also impacted by the threshold. So previously there was a threshold of 30,000. There's now a 40,000 cap before extrapolation happens. So that's a really important piece of things. With that additional legislation, there were some definitions of extraordinary medical expenses, which were just really lacking before in the prior law. And then there were tax exempt allocation updates and some adjustments for low income guidelines. And those are all really important and far reaching, as I indicated. So that's kind of where the state of child support is. That went into effect March 1 this year.
Let me ask you a quick question about that, Dorothy. So let's think of it from two different angles, right? Let's think of it from, I'm the primary parent. Before this law went into effect and now, my co-parent only has like 8 overnights a month. So I have my child a majority of the time. How does this change that for me? Am I going to be receiving more child support because I have more than that threshold?
Well, so yeah, it's important to find out because the actual guidelines changed also. So when we look at it and we put in the incomes of the parties, the cap increased, but so did the actual guidelines. So it's possible, yes, because the 0 overnights, which were worksheet A previously, that really we don't know how that sliding scale would have impacted on the prior guidelines because it just didn't exist. It was just a clear cut threshold. And so it's worth looking into, but that part is a little harder to judge because everything changed, the thresholds and the actual guidelines. So everybody's gotten those printouts that show you if you have this income and this income, it comes out to this child support amount, which is what I'm referring to as the guidelines. Those numbers were all adjusted up as well.
Okay.
The research I've seen, I have not personally done it, but Family Law Software, which is one of it's kind of like a math for law. Those are two of the softwares that we use to calculate child support. Both of those have said in running sample test cases of identical information from prior to current, they are seeing a 10% average increase in child support. So my answer is I think that's probably a safe assumption and is worth looking into if going back to court and dealing with the other spouse or your ex-spouse or the parent of the child is worth it. And that's a decision that's something that I know you are very familiar with.
Yes, that's always the caveat, right? Is it worth your peace? Okay, thank you for answering that question. And I know you're going to talk about this later. I hate to make you jump around. But the new law that just went into effect about maintenance and domestic violence, since it's sort of like, sit next to child support. Do you mind jumping over to that one? Because I think
absolutely
it's really relevant.
No problem. Yeah. And I think this is kind of in that category, the big category I told you guys, domestic violence is really being recognized as something that is impacting the overall division of assets as well as maintenance. And so effective August 6th of 2025, last year, the court now must consider domestic violence, coercive control, economic abuse, emotional abuse, litigation abuse, physical abuse, and unlawful sexual behavior. And that impacts not only whether maintenance will be awarded, but also how much. So we've all heard the standard of living thing when we're talking about maintenance or spousal support. What's the standard of living like? Well, that's one of the factors that the court has always considered. These are now those factors. So I can give you a little insight as the legislation has expanded what the criteria the courts must consider when determining the award. For amount and duration. So when I said how much you get, it's also how long you get it for. So in addition to traditional, like I said, financial lifestyle factors, we have domestic violence, which is defined under CRS 186 800.8, which is any act or threatened act of violence against a current or former spouse. That's covering crimes against person, property, an animal, using coercion, control, punishment, intimidation. So these are things we traditionally think of as domestic violence: physical harm, threats, stalking, destruction of property, hurting your animals. Those are domestic violence. But also included now is economic abuse, which refers to behavior where you impact the person's ability to have financial control of their own lives, like access to money, sabotaging their employment, using finances to coerce them or control them. Additionally, emotional abuse. Emotional abuse is a pattern of behavior intended to control, manipulate, belittle, or isolate that person. So again, those are in that verbal, same kind of gaslighting, constant criticism, that those kinds of things. New, though, is litigation abuse, which is not yet defined in the statute, but I've seen it talked about in one ruling, and I think it will continue to be defined by courts as someone who's misusing the legal system as a mechanism of harassment. And that is something that has historically been a hard bar to get someone deemed to be, a vexatious litigator is the term in the law. It's very difficult to get that. This is a different bar where we're looking at someone using the legal system to intimidate, harass, but also financially drain the other person. And then coercive control is the big term. So coercive control is that pattern of behavior used to dominate, isolate a spouse through fear, manipulation, or control. And it's a silent one in the sense that there's often not really awful messages and there aren't bruises, and it's really hard to show how someone restricted you from having access and from how they monitored you and they kept you, really in a position where you felt you were, unable to handle things on your own. And then obviously physical abuse is the one we talked about, which is a little easier for us all to define and understand. Yep. And then the last one is the sexual abuse, which it's not specifically defined in the statute, but it is defined throughout Colorado law and is explicitly referenced in the bill as being something that is important for the court to consider in determining maintenance.
Yes, thank you, Dorothy. That was really all encompassing there. Thank you. I have a couple questions for you.
Sure.
So, coercive control and economic abuse are some of, all of my clients that I privately coach deal with coercive control. That's my personal experience as well with abuse. And a big part of that is, what most of my clients have experienced. They haven't been in the workforce for 10, 15 years because the abuser convinced them to stay home with the children so that they could be in control of the money, right? Which sort of ties in with the economic abuse. So, that's part of like the standard of living that was previously pretty much the only thing that was considered, right? Like if mom would have been able to work or continue her career, she probably would have been able to make X amount of money, but because she chose to stay home or was forced to stay home by the abuser, she now longer has missed out on something like, I don't know, $300,000 total of income, potential income, and this will impact her future income in X, Y, and Z form. So that is my understanding of how it was previously considered. Is that correct?
To some extent, yes. I mean, the financial resources of the parties are also considered, which can include separate and marital property, care of a minor child. For instance, if you're a stay-at-home parent to a 2-year-old, that's part of the maintenance determinations. And then standard of living also, not only what you mentioned, but it also goes into, were you guys jetting off to Europe 3 times a year, or did you, drive down, to Colorado Springs to do the Manitou for vacation? That's kind of the, like, what level of lifestyle were you leading? But yes, absolutely. The impact of someone's ability to work is part of the coercive control analysis. And it's now even more front and center on the maintenance analysis because inability to work is one of the things specifically talked about, or like not inability to work, like the other person really saying to you, I don't want you to work, you can't work. And then if you try sabotaging that's part of the coercive control, window.
Got it. Yeah. And so, is would it, and this is very much a technical question, so forgive
Mhm.
me, Dorothy, would it require the court to make written findings of domestic violence through coercive control or economic abuse in order to meet that threshold? Would the court have to make those written findings, or could it just consider it as part of the whole?
So because of the way maintenance is required, the written findings are required to, because it's a must now, that means the court must consider it. That in law, shall and may or must and may have huge differences, and it is a must. So the court has to consider it and indicate that they've considered that factor. Now, do they have to go through and say, I've considered this, and now I'm going to say this existed or didn't exist? No, it can be a broader analysis, but they do have to indicate that they have considered the statutory factors that are included in those ones I listed off.
Yeah, and that would get triggered if someone alleges domestic violence or coercive
Yes.
control. Okay,
Yes.
got it. Thank you for clarifying.
Yeah.
And then
And oh, sorry. I'm just saying, I am seeing a lot of people starting to include that in their pleadings to
yeah,
put the court and both sides of the case on notice that they are making that argument
yeah.
as a means for property division and or maintenance.
And that are you seeing an uptick in people bringing that up just recently?
100%.
Yeah, since those coercive control laws were passed in Colorado, there used to be, I can't tell you the number of clients that have come to me and said, my attorney told me don't bring up domestic violence, don't talk about it at all, and to me, I just can't even fathom that, right?
Right.
The court needs that information, and I think the courts are now understanding, and attorneys are hopefully understanding that this is a huge piece and it's going to
Yes.
impact everything down the road. If you don't bring it up right from the get-go, the court is going to have a harder time believing it later too, is my experience. Is that something you would agree with?
Yeah, I think any argument or claim you want to make, the sooner you bring it up in an affirmative fashion, the more credible it is. If you bring it up as a defense, well, I only did that because he's been, committing domestic violence against me for 10 years. The court looks at it with a more skeptical eye because they're like, well, why would you not have brought that up in an affirmative way? So
Mhm.
I think it's a very smart thing to do, that if this is an issue in your case, really talking, well, really in your life, obviously, but then in your case, you have to tell your attorney, like, this is a key component of our dynamic, and this may become an issue in the divorce. But we've always thought about it in parenting, right?
Yeah.
But now it's come up so much more on the financial considerations. And I think it's smart that people who think it's an issue are bringing it up sooner.
Yeah, there was a study that was published recently saying that, domestic violence victims miss out on about $10,000 a year of lost wages, right? Whether it's
Oh, wow.
whatever that looks like. So most DV, including non-physical domestic violence, results in about $10,000 a year of lost wages. So
Wow.
it's really important. And I'm so glad to hear that they're considering that. I have one more question for you on this
Yes.
topic because it does affect so many people that I see. So we know that the highest conflict cases are just, instead of high conflict, I hate that term, asymmetrical conflict is really what it is, right? There's an
Mhm.
aggressor and then there's a person just trying to keep their head above water.
Right.
Litigation abuse is rampant in those domestic cases that involve abuse. But I
Yes.
think it's really interesting that they put it in this reform because litigation abuse doesn't typically occur until after a divorce is finalized, right? So post decree. So how is
Mhm.
that being considered in this pre-decree situation? Because spousal maintenance is only pre-decree, right?
Right. Yeah, it's interesting you said that because I haven't really seen this, really applied yet, given that it's only been in effect 9 months. I haven't seen the courts. I've seen one case where the issue of litigation abuse came up, but it wasn't on the issue of maintenance. But it came up in this context of coercive control. And from my perspective, I think the litigation abuse is more about motion practice and just bringing everybody back, litigating something that could be agreed upon in mediation, and rather just insisting on going through motion practice. And I always say I have a degree in psychology, but I am not a professional in this area. But my experience as a 26-year family law attorney and having a degree in psychology is that there is a desire on their part to see that person suffer and to drag them through. And that does sometimes take the form of just filing motions and taking unreasonable positions. And that's hard because as a lawyer, a lot of times I have to say, we are going to have to agree to giving them 10 days of an extension because their lawyer's been ill or this is happening. And those are, and I might need that in return, or you might need that in return. That's how, as a professional, you coach your clients to do the right thing. But we all have clients, speaking for myself, I have clients that sometimes want to take a hard line on deadlines and I have to make sure we're doing that for the right reasons. And that, like you said, is a call to action for attorneys to make sure that they're having those communications with their attorneys or with their clients to say, is it really necessary we file another motion? This could wait, or is it just because we have the funds and even maybe the legal bandwidth to do it? Yes. Is it still the right thing? And is it being done for the right reasons? So I do think it's incumbent on lawyers ethically to consider that when working with their clients. And we don't always know the motives of our clients, obviously, and we can't control that. But at the same time, I think it's a step from the legislature and therefore the bench to say we're holding people to a higher standard to really consider what's coming before the court, given how backlogged all of our family courts are as it is.
Yes, absolutely. And I'm surprised that they don't hone in on that more, given how busy the courts are.
Yes.
I think I need to have you back, Dorothy, to talk about litigation abuse because it is such a prevalent issue.
Yes.
So I won't harp on it more, except to say that in the cases where I see litigation abuse, it is typically where the abuser is pro se. So they don't have an attorney saying, this is not normal behavior. This is not what's done. This isn't how it works. They're just firing, right?
Sure.
So, okay. I will let you move on. I think we did have one question, which, let me just bring that up. Does financial secrecy count as economic abuse? Not communicating changes in salary, withholding tax returns, etc.
I mean, so again, this is new, right? There's not a lot of case law out there, but I would definitely say based upon the definitions, I think it could. Now, if the question becomes everybody's life is different. It's not, I can guarantee you my husband would not know how to find our tax returns. He wouldn't know where they were. He knows they're done. He knows they're filed. He might have even signed them, but he doesn't know. That's just my role in the family, right? So just the nature of something happening doesn't mean it's automatically economic abuse. But again, we're looking at the patterns and we're looking at whether or not that's being done. In this case, it sounds like to hide information and to keep someone powerless and to prevent them from being able to do whatever it is, participate in the litigation or be able to, pay bills or whatever that might be. So it has to be looked at in the broader context. Yes, it certainly could be economic abuse.
Yeah. And would they consider that with sort of the threshold that you'd have to meet the bar for like a 16.2 E10 omission or misrepresentation of financial information? Is that sort of the bar?
I mean, yes, but again, most of the time, I think the question is really talking less about once the case is filed, and so for those of you who don't have any litigation pending or haven't been through this, the 16.2s are mandatory disclosures that are required, but those start when the case gets filed.
Right.
So if this is from before that, that's a different ball of wax. If it's after, yes, if we're hearing that, no, we didn't file taxes when actually there's a tax return out there, obviously that's a bigger concern or question mark for me. And I think for the court, that would actually really support the claim there had been economic abuse, because when you have someone who doesn't want to give it up when they have to give it up under court order, that tends to really support the narrative that they were unwilling to share that information as a spouse.
Thank you. That was a really thorough answer. Okay, let's see. I will let you take it.
I wanted to point out, though, from the domestic violence side of things, there are some additional mandatory considerations for the court now. It's kind of interesting because they're not for each category. So for purposes of property division, the court now you have to disclose at the time of your filing that there's a protection order in effect. And that protection order, if it's issued within the last 5 years, it will be considered by the court for property division. And that's huge. That's totally new thing. And that's important. And the court will weigh that in determining an equitable distribution of assets.
Yeah.
And again, very important.
And when you say property division, just to define that for everyone, it's essentially your assets and debts and how those get split up.
Yes. And so in Colorado, we have fair division. It is not, a lot of times people say equitable, which most of the states I practiced in before I moved to Colorado looked at the idea of an equitable or equal division. We call it fair. And fair under our statute is still looking for it to be equitable, but it doesn't necessarily have to be. Because equity is a concept that is in that's what the domestic relations courts are. They're courts of equity. They do what's fair, and so the court does have a lot of latitude to make a determination of what is fair based upon the specific factual circumstances of your case. And so that is now something the court will be considering for purposes of that equitable division if there's been a protection order issued related to these parties.
Got it.
Also, it does impact, there's that underlying idea that domestic violence does impact the division of assets, which is also a new, I don't think it's not been in writing before. It's a new concept. And for all of us that have been doing it forever, I don't think it's foreign to think that the court would have considered it in considering all the factors, but now it's explicit, which is, like I said, a recognition of the importance of that from the Colorado legislature and the bench.
Mm-hmm.
The other important thing is, and this is only on custody side, but it is indicated now that the court must consider criminal history in custody cases. And again, you kind of think, oh, well, that probably was happening before. Yeah, it probably was happening before, but now it's codified, meaning it's part of the law. And that's important to know that, again, there's that safety component for children, which is part of this, not just the spouse, but, we're talking about some safety considerations for the abused spouse, but also for the children, which I think is really important for all of us parents out there.
Yeah. And, there's actually a bill on the House floor right now, HB 261309 here in Colorado, that is basically restructuring the flow of how domestic relations judges have to manage their caseload. So
Yes.
if domestic violence is alleged, according to this bill, which is so close to passing, hopefully it will, but it requires that if there's any allegation, the court must make written findings. They have to address it specifically in the order, which is just fantastic because it essentially creates a flow, right? Like, is there domestic violence? Yes, this way. No, this way, right? So I love that they're starting to think about this more holistically.
Is that you spoke on the floor of the
I did. I testified
House
twice. Mm-hmm.
That's
Yeah.
wonderful.
Yeah.
Wonderful to advocate. And then speaking of the idea still of domestic violence and child safety reform, this is a little bit of an older change. It's a 2024 change, but I wanted to highlight the fact that, again, the court said we need enhanced training for CFIs and PREs. So those of you that aren't involved in litigation yet, CFI is a child and family investigator, a PRE is a parental responsibilities evaluator, and they come in and make a review of the circumstances. Depending on the level, it can involve psychological testing or just interviews, and they provide reports and recommendations to the court. And I think the court started realizing they did not have the education in domestic violence dynamics, because a lot of the CFIs are actually just lawyers. And some of the great CFIs have been doing a great job getting educated and getting master's degrees in the area of psychology or, sociology or whatever it might be that will help them understand better. And I really appreciate that. I just worked with one that was amazing that has really gone to do that so she can understand the impact of her recommendations on the families, which I think is wonderful. But that enhanced training is something that is meaning where if these people get involved, which that's another thing we could talk about another day, Kat, if these people get involved, we make sure that they have at least the training that's necessary to educate the court and to make sure that they are looking for this. And it does mandate that they have a detailed reporting of any domestic violence allegations. And then they give the court, sort of their 2 cents about what they think. They do not make determinations in the sense that is the job of the judge. That is not the judge. That is not the job of someone helping the judge, but it does give information. And then there's also some stricter guidelines relating to parenting time where there are DV cases that were part of the 2024 child safety changes relating to CFIs and PREs. And they also in that started recognizing the coercive control as abuse. So that was sort of the precursor to talking about coercive control impact on parenting.
Yes.
Yeah. And that's, I think those changes were, I can tell you as a practitioner, I have seen impact on the kinds of reports that are coming out, because I think that it's created a new focus and a new opportunity for education across the board, not just the people making the investigations, but also lawyers helping the clients do a better job, be educated or advocate for themselves.
Yes.
Because in these investigations, because sometimes these investigations are kind of like being interviewed by the police, because you're so worried you're going to say the wrong thing.
Yes.
And you're going to impact the rest of your life.
Yes.
And really, in general, most of the people that do that job are really advocates for kids, and they do really want to do a good job. But again, another day, if we have a CFI or PRE involved in your case, it's very important you strategically think about that and how it could impact your case.
Yep.
And I did want to point out a couple of considerations before we move on from this topic when thinking about if you should bring up the issue of domestic violence, primarily coercive control in your filings.
Mm-hmm.
Again, I would advocate that you should do that in the beginning if you're going to do it. The considerations I have is, were you ever prevented from working? And prevented is the key term there. Did your spouse control or restrict your access to joint finances? Were you ever subjected to emotional manipulation or intimidation? And we're really looking for a pattern there, not like that one time this one thing happened. That might be domestic violence, but that's not coercive control. So thinking about that. And then the last one is the use of the legal system to overwhelm you. And that's that litigation abuse piece. So thinking about those and whether or not whether or not those have impacted you, because those do appear to have a huge potential impact on what the court will view as a fair and just maintenance award and
Mm-hmm.
potentially property division. So I want to just kind of remind everybody that my reading, my belief is what we're going to see is broad discretion coming from the courts with their ability to interpret and apply these new factors. And because we don't have case law that says this is exactly what emotional abuse looks like, this is exactly what coercive control looks like, the courts are going to be evaluating those dynamics on their own. And it's really important that we're thinking about that, developing a strategy of how you would get that information together, especially if you're in an abusive relationship and you're trying to think about how to prepare yourself for that fight. That is something you need to be, ready to do ahead of time.
Yep. And shameless plug, I'm going to be teaching a documentation workshop starting June 2nd for 4 Tuesdays about how to put your documentation together, regardless of where you are. If you're thinking about getting divorced, if you're right in the middle of it, and if you're post-decree and you need to go back to litigate, it basically teaches you the framework for how to present that sort of evidence to the court, whether it's a combination of like written evidence and how to organize that and how to present it in combination with testimony, right? Because as we know, Dorothy, as you know, your testimony is evidence. And the way that you get the court to see your testimony as credible evidence is building a pattern of credibility for yourself and against your abuser. And so that's a big one. So if you're interested in that documentation workshop, that's more information on my website.
Yeah, I think it's interesting you mentioned that because I was in preparation for this kind of reading some thoughts from colleagues, what they have maybe put on their blogs, on their websites, or what people have been talking about. And the thing I wrote down that a colleague had written down was that these changes may make cases more adversarial and document intensive because of Colorado is now showing this priority for safety and family involvement. And there's a thought process that what kind of the old guard is going to be changing, and people are really going to have to be sort of accelerating, proving their case, because now it has so much more impact.
Yeah.
Before it was sort of like, I don't want to look like a jerk in court. Now it's like, wait, I could lose a lot more money if this is proven. And to your point, credibility is key. There is nothing a lawyer can do on the stand for you. You have to do it. So the only way you can do it is be prepared and know what matters and know how to present it and know how to present yourself. And that's so difficult. But like you said, proper preparation is really the key to being able to present yourself in a credible fashion where you sound articulate together, you have your timeline, because it is so emotional and difficult. Sometimes people panic because they're not prepared. So I think that's a great advice about being prepared with documentation and for testimony. Big important piece.
Yep.
All right. Well, we have moved around a little, so I'm going to take us back to a less exciting topic, which is just to point out there's a new Colorado Rules of Family Procedure cases that are out there. It's a separate procedural system, and that was adopted in 2025. It's kind of like as we were talking about with domestic relations cases, they work a little differently than the average civil case. And they are attempting to make it a little less adversarial. It does apply to all Title 14 cases, which would be any marriage, any litigation relating to marriage. Again, not so much excitement for us for our topics, but it's important to know because it does have an informal domestic relations trial option, which would remove kind of cross-examination and allow the judges to directly ask questions of the parties. And again, this probably impacts pro se a little bit more than lawyer litigation. I haven't noticed a big difference personally when I'm litigating cases, but I think from a pro se perspective, it has. And one thing I will say about Colorado is they know how to do pro se litigation. They really have the self-help resources are abundant.
Yeah.
And I know not everybody that talks to me or everybody that's listening today has the ability to hire me or hire a lawyer. So I, definitely advocate for people to educate themselves and make sure that they're checking out the self-help sections, both online and in person, even at the courthouses, if you need it. Yeah.
And so let me just ask, if I'm a pro se party and I'm thinking about building my strategy for a hearing and how I'm going to represent myself during that hearing, how do I use this new law to my advantage? How do I bring it up in the court, and how can I take advantage of it?
I don't know that there is a huge advantage other than you have the opportunity, because people that are pro se freak out. They don't know what to do. I just had a pro se hearing the other day. It was a very limited issue about a passport, but the lady was pro se on the other side, and she was like, I don't know what to say next, or I don't know what to do next. And so taking it out of a procedural sort of nightmare where, I don't know how to go to someone else's job and do it. So I don't expect you can come and do my job. Right. So at that point, the judge was just like, you can say whatever you want at this point, but that's it. Because he couldn't give her any more advice. My point on that, I think on the opportunity to have a direct conversation with the judges, they have the ability, they don't often want to know the stuff I'm asking. Sometimes they only want to know 10 things. And I don't necessarily know all 10 of those things because maybe they have formed their opinion based on the pleadings. They've got their credibility. They have a couple factual questions they want to know. And the thing that may help with this is it may streamline the opportunity to go into court and just say, I want this to be informal. I want the judge to be able to ask me the questions they need to know so I can get an answer. And I think that kind of actually factors into one of the changes that's also just evolved in the law, which is the LLP. It's a
Yes.
licensed legal professional. And I always think of it as, in my brain, call it sorry, first. In my brain, I call it a limited licensed paralegal, which
Yes.
is not the correct term. It is a licensed legal paraprofessional. But the person who is doing this is a paralegal. They've gotten educated. They've taken a test, and the Colorado law says they have the ability to help people in the legal system beyond the scope of a normal layperson, but not to the level of a lawyer in most cases. And I think that's exciting. I think access to justice is literally, it's sort of my passion. And I think that it's so, Colorado has a lot of limitations because we do have some very rural areas where there isn't opportunity for access to justice. And then on the other hand, we have financial limitations. And having a paraprofessional who is skilled in this area, who can help you with paperwork, who can help you with something that's not that contested, but you
Yeah.
maybe are, maybe you're worried to go into court on your own, you're not ready, or maybe you just need support through the process.
Yeah.
Because a lot of times, you don't want to pay a lawyer with 26 years of experience at my hourly rate to support you through the process. That you would be talking to my paralegal with a lot of that, because I don't want to charge someone my hourly
Mhm.
rate just to support them, because even though I want them to have the support, it's so important you have a team that supports you through this. And that team isn't just at the law firm,
Yeah.
obviously. That involves people like you. And I think it's the benefit of the LLP is just that great opportunity to have a little. You have the support, you have the opportunity to have someone get you through the process, much lower cost, and have hopefully a better outcome than you would have if you were trying to navigate the legal process all by yourself.
Absolutely. And the way that I have been recommending this to my clients is, they don't want to have a full retainer attorney because
Mhm.
that person is literally answering emails to the opposing party, and
Yes.
it does generate, bills very quickly.
Yes.
So the advantage of having an LLP, and what the law just did in Colorado, is it allowed not only an LLP to file
Mhm.
things on your behalf, participate in motions practice, which means if they're filing a response for you or filing a motion, they can do that. Now they can actually come into the courtroom and represent you during your hearing. So, like you were saying, some pro se parties, it's really overwhelming, especially
Yes.
when you're representing yourself in the face of an abusive partner,
Yes.
and so what they can do is they can be there to object based on certain things. I hate to say it, but it really is very much a game to some of these abusers. And so
Yes.
having somebody who can come in and represent you and know the rules of the game, because, I've seen abusive parties get custody when they shouldn't have, based on a technicality of the law.
Right.
And so having an LLP come in and represent you and protect you from those costly, simple mistakes is huge. And so that's what I've been recommending to my clients who can't pay for full representation. Hey, have an LLP, do unbundled services, and then make sure that they're
Right.
prepared to represent you in court that day. It's huge.
Yes. And I think having the LLPs are great. I always just caution people because there are limitations on what they're able to do.
Yeah.
And I I think it's one of those cases. The LLPs I've had dealings with, professionally, have all been really, I think, amazing at saying, this is what I do. This isn't what I do. And
Mhm.
so they're good at saying, like, this is beyond the scope of what I feel comfortable with. And like lawyers, like some lawyers don't like to go to trial. That's, some lawyers only mediate. Like, everybody has a different role. So just making sure when you do get involved with that LLP, like you said, that you're making sure that they understand what you're looking for. And honestly, one of the things I've had clients do over the years that I think is wonderful is enlist victims advocates to assist them in just that support role.
Yep.
Come and sit in the courtroom with you. So you're, number one, you're not alone in the courtroom if there's no active protection order. But number two, just making sure that you feel supported in the process. And I've definitely, for clients, many times asked for the bailiff to make sure that people are staggered. They leave in a staggered fashion. So either we can get to the car and leave first, or, it's important that you think about the resources that are available to you that aren't just in the law. And so that making sure that you are protecting yourself even in the actual courtroom, because I'm going back to the courthouse a lot more than I was before.
Yeah.
And so, and those kinds of abuses can happen. I had on the witness stand, I had a man who just stared down my client his entire testimony. And I objected, and I asked the judge to instruct him to stop staring at my client. And the judge was like, I agree. Like it didn't even matter what was being said at that point.
Yeah.
It was clearly for the purpose of intimidation, and the judge wasn't standing for it. So again, those are those little things where, if that person had been there alone, I'm not sure she would have been known to do that.
Yes.
And so it's important you have someone to help advocate for you.
Yep. And for those listening, no matter where you are in the country, there's a website, Alliance for Hope. So if you search for Alliance for Hope, they have a directory of family justice centers and different ways to access support and advocacy. In Colorado here, we have the Rose Addendum Center, and they are an excellent source of support for domestic violence victim survivors.
Yes.
Yeah. Thank you, Dorothy. That's so, yeah. So helpful to have somebody there who can just advocate for you, especially if you're feeling frozen,
Yeah. Yeah.
Yep.
Well, yeah. And I think importantly too, one of the things that happens a lot, which is another change, is when there are violations with the custody agreement, and people are, sometimes you're reticent to bring it up because it's another fight. But again, Colorado is saying, like, we're not going to put up with this. And they have actually, the Colorado Court of Appeals said prosecutors can bring a criminal charge per child. So if there's a withholding, like the non-custodial parent doesn't bring back the kids on Sunday at 6, then there can, whatever the violations are, and the prosecutor deems it sufficient under the law to file criminal charges, then they can actually file one charge per child, which is new because it was previously, a child in a violation of parental kidnapping or whatever it might have been as a criminal charge. And then they were just one charge. Now it's per child, which I think is just another thing to point out, that Colorado is taking the safety of everyone involved really significantly important.
And that's great on an accountability standpoint, right? What I'm hearing flagged is there's a case of a mother named Rachel Pickerel Hawkins here in Colorado. Are you familiar with this case, Dorothy? She was sent to prison because her children refused to go to their father's house. He's an ex-Colorado sheriff, and he's actually, the case is pending for criminal charges for child sexual assault of his children.
Wow.
The children refused to go to his house for parenting time, and the mother was jailed.
Oh, wow.
Because the children wouldn't go. So they held her accountable. So I hear this, and I think this is a good piece for accountability, but it really freaks me out in cases like Rachel Pickerel Hawkins, if how that's going to be applied. And I think it'll be helpful to have a history of domestic violence, written findings of that in your case, so that can be taken into consideration, right? If there was established that, one party was abusive, and that abusive party ties into that litigation abuse piece, right?
Yeah.
That abusive party is dragging the protected parent to court to file charges when the kids refuse to go. So it'll be interesting to see how all of these interact with each other. But I do like that there's that litigation piece being woven in, and the domestic violence pieces to, basically create a case history, like a waterfall, right?
Yeah.
Is this being weaponized? And if so, how do we preemptively prevent that from happening? And I think that goes back to what we were talking about early, bring up domestic violence as soon as you can, right from the beginning. Yeah.
Yes. And I will say to anyone feeling kind of the way you're feeling about this, it is very uncommon for a custodial parent who has kids that refuse to go to be criminally charged, even though obviously it can happen. Especially, ages. But again, it's like the hard part about being a family law attorney, excuse me, is everything is so factually specific.
Mhm.
And that's why, like you said, I like the example of the waterfall, because it is every case looks so different. And so, if we're withholding a 2-year-old because they don't want to go,
That's different.
that falls on deaf ears when you can put them into a car seat and take them. If you've
Yes.
got a 16-year-old who's like, nope, not going, what are you going to do? Right.
Bingo.
And so I do see a common sense approach to that in general with contempt. I don't do any of the criminal side of it, but contempts for violation of family court orders. I think there's a very common sense approach by judges to say, this isn't a violation by the parent because they're not
Mhm.
capable of being compliant. But on
Mhm.
the other hand, it is really, obviously as an officer of the court, I always tell people it's your job to find a way to comply with the orders. But this is why we need to be so conservative and cautious and strategic before the orders get entered. Because
Yes.
if we make the orders and we don't want to follow them, but I understand that, but we have to kind of go back 10 steps and say, well, what can we do to get better orders? How do we strategize that? How do we show the court what's really happening or what the wishes of the children are, and things like that are part of the process. And so, that's one of the things I want to advocate for too, is just that, back to your point about preparation. It's just so important to understand that what goes in the order will be binding on you as well as your ex,
Yep.
and not to your kids, but really your kids. Your kids will
Yeah.
be so extremely affected by what's in there, and it's really important that we're considering that and really strategizing how to best use the law, or use whether it's using the law to defend ourselves or using the law to get the best possible outcome.
Yeah. Well, and one question that I have for you too is, now that the courts must make written findings about domestic violence based on the changes we were just talking about,
Yes.
every state's different. In Colorado, there are counties where, your magistrate will change every 2 years. They rotate.
Yes.
Colorado is one of the few states in the country where we don't have dedicated domestic relations judicial officers. They float. They go between criminal or domestic or whatever it is, civil, right?
Yeah.
That's a thing with Colorado, where our judges are not dedicated DR judges. So you could have somebody who, is a judge who was, a CPA who filed
Yes.
tax returns for people, who's appointed as a judge, and they step into the courtroom and day one they have a DR case
Oh yeah.
involving domestic violence, and they know nothing about this, and the training is so limited.
Yeah.
So having what you just talked about, these changes in here where they're required to make findings, they're required to look at it. The language is really clear about what constitutes domestic violence, so that you can get those written findings of domestic violence on your case from the get-go. Because if your judge changes, and the chances are like 95% that you will not have the same judge over the course of 4 years, that is there because there's a look back. Those judicial officers are looking back at prior orders. They take judicial notice, right? And so they can consider the case history if it's been documented, which is why it's so key to make sure that you're presenting those facts to the court in a way that they can act on it, right? Because there's behaviors that the court cares about and there's behaviors that don't. And sometimes both of those two things fall into the sort of category of domestic violence, but it's really important that we're shifting those things that maybe they don't recognize as domestic violence into the column of domestic violence by the way we present it. And so, yeah, I love that there's so much language coming into the statutes about domestic violence and coercive control. They used to really rely on the violent incident model for domestic violence, right? Which is what you talked about with things that leave bruises or stalking, things like that. Now that it's shifting to coercive control, there's so much greater opportunity for safety for children and abused parents.
Yes. No, it's completely true. And to talk about the judges, I mean, I think Colorado has a lot of really amazing family court judges, which I get to practice in front of. And I think the majority of them work so hard to do a great job. I just had a judge the other day go over and above to talk to the parents about how important what they're doing is for their child, their very young child. They're getting divorced with a 3-year-old. And and that was a judge. It's not a domestic relations devoted judge. He also hears criminal cases and civil cases. And in conversations I've been in with judges recently, on a board I sit on, a lot of the judges are advocating for more training for themselves, but really for the new judges coming in, because some areas of law are so clear. The criminal law, you have these factors, you must prove them in this exact fashion, or it's not, it doesn't apply, right? You're not guilty. But family court, like I keep saying, is all about credibility. And as I tell my clients, like, if you want to think about your case, the easiest way to think about it is a brick wall. Each and every brick matters to make a wall, but in and of itself, it doesn't matter. Like, it's not dispositive. And then you have all the filler in between, the mortar, that creates the strength of your case. And so you have to continue to build on that brick wall. And that can be so hard to present, so that the court understands. And that's another piece, whether you're doing your own research or whether you have an advocate for you, like an LLP or an attorney, you should research your judge. You should understand, have they sat on the family court bench? They are, I think, again, most of the judges I appear in front of, not only do they know the law, they're citing the law in their rulings, they're making the required finding. It's so unusual to have someone not do that. Mm-hmm. But like you said, then the next time you go back, you have a new person, and you have to keep documenting your case and building that brick wall so that the next person you appear in front of, because they retire, they move. A lot of the judges, even since I've moved here 5 years ago, have changed. Yeah. And so it's, there's a lot of transition. And so you have to be prepared to be your best advocate with your team.
Absolutely. Absolutely. Final thoughts to leave us with today, Dorothy. If there's one or two big things that you want us to take away from our conversation today about what's really critical, what would that be?
Sure. I think what's really critical, in family court, especially based on the topics we've been talking about today, I think it's really, really important that you, number one, don't just trust that your lawyer or your legal advocate will know how to navigate the system. Yeah. I tell my clients all the time, this is a team. And at the end of the day, I go home to my family. I don't go home to yours. So I have to make sure that you're participating in this as much as I am. I can't do all the heavy lifting. So it feels like sometimes you're like, well, I just want to hire someone, like I hire my CPA to do my taxes. They can't do your taxes without all the information. So my point about that is just be ready to participate in your case. And even though it's hard, there's a reason why people become family law attorneys. It's hard. We know it's hard. It's hard for us too. And so we want to work with you and make sure you have the best outcome in your case. So be prepared to put in the work is the number one thing. And be prepared to be as honest as you can with your lawyer, because sometimes the things that come out on accident are the things that are the most important, to me. And the last thing is really what we're hearing is the courts do care, but you have to have the information to present it. So preparation is key. And that the way to prepare is to understand what you need to prove, how to prove it, and then be prepared to do that in the form of documentation and testimony. And I think that it's almost like having another job. It's so much work for the litigants, but it is, at the end of the day, as a parent and as a family law attorney, I can tell you, when your life, your liberty, your finances, and your family are on the table, nothing should be more important. And so, you have to believe that, and your team around you should believe that too.
Dorothy, thank you. I can't thank you enough. This was so impactful. I think it's going to give our community so much to think about, what new protections are available. I just appreciate you donating your time and your expertise. I am going to throw Dorothy's information back up for all of you to see. And let me just make sure that you can see that over here. Here we go. Bumble around that for a minute. There you go. And I wanted also to let everybody know that the next Lunch and Learn we have will be May 27th with a financial expert, Brianna Besky. So keep an eye out for more information about that. If you haven't signed up to receive my newsletter yet, our lovely Shruti will drop that in the chat right now. And then I will just leave this up here nice and big so everybody can see it, so that you can take a screenshot of Dorothy's information if you want to get a hold of her. Let me go back here to make sure that there it is. There we go. Her information is nice and big on the screen for you so that you can see that. Dorothy, thank you for your time and your wisdom. We're definitely going to have you back to talk about some of those other topics. To everyone in the community, thank you for being here. I look forward to seeing you on the next Lunch and Learn. If you want more information about the documentation workshop coming up June 2nd, there's a link on my website, and there's a link in the image right here for you to take a screenshot of if you want to visit. I'll see you all next time. Thank you.
Thank you.